Hello and welcome. My name is Jeremy Glover, and it's my pleasure to introduce our latest Fenwick Elliott webinar, the last for 2023. And this month, we're turning our attention to bonds and securities, looking at the key considerations those providing and maybe calling on those securities need to be focusing on in the current economic climate. And I'm really pleased to be introducing as our speakers two hugely experienced practitioners, my colleague and fellow partner Claire King and Mathias Cheung from Atkin Chambers. Claire comes recommended as a global leader in construction by Who's Who Legal and for international arbitration in Legal 500. She has a wealth of experience with bonds, including representing the successful party in the Court of Appeal NIDCO and Santander case. In her spare time, she's a leading light in the Women in Adjudication group. Mathias also comes highly recommended in the legal directories, both Chambers and Legal 500, being described as an absolute superstar with a great eye for detail, someone who understands highly complex and technical subject matters, all of which can be rather useful when it comes to looking at bonds and securities. So just a reminder, you're all on mute. Please do send in any questions you may have, and you'll be able to find the slides on our website later in the week. A link will be put in the chat during the webinar. But over to you, Claire.
Thank you very much, Jeremy. I'm just moving the slides. There we go. Today, we are going to be covering the following. First of all, we are going to do a refresher of the basics in relation to bonds, guarantees, and ABI bonds, which is sort of weird hybrid somewhere in the middle. We'll then use that to sort of the baseline to run through what you need to do to set up your project and your project securities properly right from the beginning. And that's really focusing on the essentials, taking into account the current economic environment. I mean, these things always matter, we should say, but the consequences of getting them wrong are perhaps will be more strongly felt in the current economic climate, potentially. Then we'll look at protecting your position when things start to go downhill, things are going wrong on the project, and there's a potential that a claim may need to be made on these on-demand bonds or guarantees you've provided. We'll look at it from both the contractor's and employer's perspective. What do you need to do if you are going to make that claim, or how to defend a claim? So with that introduction in mind, we'll just start with a refresher of the basics. Now, when it comes to on-demand bonds, terminology is very confusing. The labels given to on-demand bonds vary a lot. You know, you've got references to demand guarantees, where they're not guarantees at all. Performance guarantees, where they may either be an on-demand bond or they could be a guarantee in the true sense of the word. Performance bonds, or standby letters of credit, which is the term of art used in the US for performance guarantees, on-demand bonds in that sense, but also in trade more generally, but has the same law applicable to them as on-demand bonds. So the terminology is very confusing, and it's often confused in the instruments themselves. The important point is always to look at the content and not the label attached to what you've been presented with. And that is the case all the way through, right from the beginning to the end when you're making a call. With an on-demand bond, the key thing is the bank or whoever has provided that insurance company will make immediate payment upon presentation of a compliant demand. And I've put a sort of definition there. It's an irrevocable undertaking to pay a specified sum to the beneficiary in the event of a breach of contract, rather than a promise to see to it that the contract will be performed. So it's a promise to pay on its own, in its own right, in its purest form. It's a separate contract. There's no inquiry into the rights and obligations of the contractor and the employer when it comes to making the demand or paying out in its purest form. And they're more likely to be issued by a bank, an insurer, or financial institution, rather than, for example, a parent company. So we'll look into defences in a bit more detail, but the only real defence is fraud. There's also a possibility of an injunction under the construction contract itself, but we'll come to that shortly. Now, as well as the terminology, there's various different types of bonds, and I'm typically these are often on-demand bonds. But again, just to really emphasize this again, you need to look at the wording of the type of security to ensure that it is actually an on-demand instrument as opposed to something that's contingent or guarantee or somewhere in the middle. So we have tender bonds, which are aimed at giving assurance that the contractor is serious about a bid, and some jurisdictions use these very widely and they are compulsory under some laws. And that will typically allow a call if the contractor withdraws the tender without the employer's consent, the contractor is awarded the tender but then doesn't enter into the contract, or they don't provide a performance bond. You also have advance payment bonds, essentially providing protection so you can call back money you've paid in advance to get perhaps a turbine or a big piece of kit that's needed at the beginning of the job. And again, that protects the employer from funds perhaps being diverted. Retention bonds, these can often be guarantees as well, but they're given in lieu of retention, reduced at practical completion and then typically released at the end of the defects liability period. Performance bonds required to cover a percentage of the contract price, and they're generally a constant percentage until practical completion, and then they reduce and expire at the end of the defects liability typically. They're perhaps some of the most common ones, and we see again that terminology performance bond versus performance guarantee, when they could be a guarantee or a bond, used interchangeably. So that's a particular one to pay attention to. And then off-site material bonds, protection again for the employer who's coughed up a lot of money for materials, but perhaps they're not on site, and they want protection that they'll get that money back, for example, if there's an insolvency event. So there are the various types you see, but again, it's really crucial to look at the actual wording of what you've been handed. So on-demand bonds, grounds for stopping a call. Well, under English law, and Mathias is going to look at some variations in law on this worldwide a bit later. The only two ways to potentially stop a call are what's called the fraud exception, and potentially, but much harder, obtaining a injunction under the main construction contract, i.e. you don't have the right to call this bond under the construction contract. So let's look at the fraud exception. There is a very famous case that if you study the law or this in any detail, you will know about, which is to do with Libyan greenhouses. And I won't read out the quote, it's there on the slides, which you'll be able to see on our website afterwards. But the key point is this test at the end, a bit in bold. The only exception to calling a true on-demand bond is when there is a clear fraud, step one, of which the bank has notice. So the bank has to know about the fraud at the time the call is being made, as well as the fraud existing. So there's a two-part test there. And I think the second part is quite often forgotten about. And just looking at a bit more case law on this, the timing of when the bank knew about that is really key. This quote here, it is nothing to the point that at the time of the trial, the beneficiary knows and the bank knows that the documents presented under the letter of credit, so it's another type of bond, the law is the same, were not truthful in a material respect. It is the time of the presentation that is critical. So the bank has to know about the fraud when the demand is made, not later down the line when things emerge that people know later on. And that is quite a heavy burden. Well, it's a very heavy burden on the bank seeking to resist payment, or the party seeking to restrain the bank from making payment on the basis they know of the fraud. I mean, practically speaking, unless it's extreme circumstances, how can you prove that a bank knows of a fraud? It's very difficult. So that is the reality and the difficulty with restraining calls being made on true on-demand bonds. It's slightly different, a little bit easier, restraining the beneficiary making a call, but still high tests. So this is just some of the case law that's come out on this point. I'm going to say the first case name wrong, but Lisa, you must positively establish that demand would not comply with the contractual mechanism. Seriously arguable is not enough. It has to be much higher. You have to establish it. And that's establishing that the call is not allowed under the underlying construction contract, not on the terms of the face of the on-demand bond itself. Slightly different test in Simon Carve's. A strong case for injunction was sufficient, but again, there is no legal, and it said, more helpfully in the other cases, there is no legal authority which permits the beneficiary to make a call on a bond when it is expressly disentitled to do so. So if the construction contract, it's clear they do not have the right to call on that bond under that underlying contract, then you can get an injunction. Again, slightly different wording in the Doosan case. You have to have a realistic prospect of showing the employer had wrongfully failed to issue a taking over certificate in breach of contract, and the demand would allow the employer to benefit from its own wrong. So the takeover certificate should have been issued. That would have invalidated the on-demand bond. So that's again, it's a dispute under the underlying construction contract, which allows would allow you to get that injunction. Finally, the MW High Tech Biffa Waste Services dispute about whether there had been a default under the contract so as to allow a demand on the performance bond to be made, and no injunction was granted using the Perma Stilisa case, so a high test. And then just some commentary generally on the way the English law looks at it. It's quite strict English law, from the law of guarantees, which is perhaps the Bible of these sorts of securities. It seems unlikely that the ground for interference would be extended by an English court any further than, at the very most, a clear case of total failure of consideration, illegality, or, and this is the key one, failure to comply with a condition precedent. So something hasn't been complied with under the contract and you don't have the right to make the call. Any wider exception would be too likely to subvert the value of the performance bond as a commercial instrument to find favour with the court. So it's a theme of English law that we're strict on this, these obligations compared to perhaps some other jurisdictions. And then finally, what is a guarantee? Now this is a different thing. Guarantees are secondary obligations. You can't just make the call and that's it. It's just all on the face of one document and it's a valid call and it gets paid out. You have to look at the underlying contract. A contract to guarantee in the true sense is a contract whereby the surety, the guarantor, promises the creditor to be responsible for the due performance by the principal of his existing or future obligations to the creditor if the principal fails to perform any of them. So if the contractor fails to do their job under the construction contract and you've proved it and you ascertained, you know what the loss is, at that point, then the next person will step in. The creditor must also be a party, and the liability is the same as for the underlying contract. And that's important because obviously you've got to prove what that liability is. And quite often in guarantees, you see a clause saying that an amendment to the underlying construction contract, or the underlying contract, will not relieve the guarantor of their liability because of a previous strain of strand of case law in English law, which says otherwise they're free to walk away. So you will see that clause in a guarantee. And then finally, Section 4 of the Statute of Frauds Act 1677, so going back a while, it has to be in writing and signed because of the importance of what you're agreeing to do. So with that, I will hand over to Mathias, who's going to talk to us. We'll have to go back a few slides about hybrid options.
Right, so thanks, Claire. And as if that doesn't make things complicated enough, there is something always almost in between an on-demand bond and a guarantee, which is secondary in nature. And that's something which some of us would call a conditional bond. Now, what that means, actually, in some ways, the name sort of gives it away a little, because it means that rather than just presenting a demand as you would in an on-demand bond, which is simple enough, there are other conditions under the bond which you would have to satisfy in order for you to make a valid call on the bond and for the surety to have to pay out under the bond. Now, one might ask, well, how is that different from a guarantee then? The short answer is, in practice, it might not differ that much. But there are some subtle differences in terms of how you interpret it. So, for example, when you look at a conditional bond, there may well be conditions attached to the requirements as to making a demand. But actually, if you look at the obligation owed by the surety, the bondsman, under that bond, it would say something like, the bondsman or the surety owes obligations, primary obligations, as a primary obligor, meaning that it is a primary obligation rather than a secondary obligation or liability arising only when there is a default of an underlying contract. So in that sense, it's still in the form of a bond, in the sense that the surety is the primary obligation holder under the bond, and they owe an upper primary obligation to the beneficiary. So that really is why it's not really quite a guarantee, but sort of somewhere in between. But nonetheless, despite that sort of terminology and the sort of primary secondary obligation, that sort of distinction, when you look at the substance of the bond in practice, when you have to call on it, it's actually not very different in some sense from when you're actually trying to call or make a demand under a guarantee. We'll come back to that a bit later, but I just want to give you an example of what a conditional bond might look like in practice. So I think a very good example of that is in fact what Claire has already mentioned earlier. It's called an ABI bond, an ABI model form of bond. ABI, of course, stands for the Association of British Insurers. So we see that quite a lot in the UK, but you also see similar types of wording or similar types of provisions or conditions being replicated in other bonds in international projects as well. But just to take the ABI bond as an example, if you look at clause 1, which you should be able to see on the screen, the wording of it sort of tells you why it's conditional. Because on the first hand, if you look at the first bit of clause 1 of a standard ABI bond, it suggests that, well, the guarantor sort of guarantees to the employer that in the event of a breach of contract, they would perform the contract by discharging the relevant losses and damages sustained by the employer. So that sort of wording is still pretty typical of even an on-demand bond. But when you look at the second part of the sentence, that's when it starts getting trickier, because then it goes on to say that it would the surety or the guarantor would only discharge the losses and damages which are established and ascertained pursuant to and in accordance with the provisions of or by reference to the contract. Quite a mouthful. So actually, quite a few times, if this is the first time you're looking at a bond like this, you have to read that a few times to understand what it's trying to say. And you look at the final part of the sentence as well, it also says that not only does the loss have to be established and ascertained, it also has to take into account all sums due or to become due otherwise to the contractor under the contract. So to break that down, essentially what it means is, first of all, you can't just call on the bond as long as you've suffered some loss and damage, or you believe you've suffered some loss and damage under the contract. You have to establish and ascertain that loss and damage in accordance with the terms of the contract. So one has to go back to the underlying contract. Unlike in an on-demand bond, you have to go there and see how you can establish and ascertain it. That's the first part. And then the second part is you don't just call on the bond for the loss and damage that you have sustained. Rather, you need to almost take a net balance or take an account of what is the net balance due between the parties. So almost a bit like in a situation where if you have a situation of insolvency, for example, you would normally have a statutory set-off of the sort of cross claims due between the two parties. That is a sort of a similar situation or similar type of sort of netting off exercise, which is envisaged by the ABI bond. So actually, unlike an on-demand bond, what you have to do under a conditional bond, such as an ABI model form of bond, is to go away and try and establish and ascertain what is the net balance due between the parties, and then you call on the bond based on that established net balance. Now, we'll come back later to talk about how you can do that when we talk about what happens when you have to make a demand on the bond. But basically, that is what sort of sets apart a conditional bond from other forms of security like an on-demand bond or a guarantee. So be careful not to mistake these different types of bonds, because that really determines what you need to do when you have to call on them. So on that note, before I go on to talk about that sort of that side of things, I'll hand back to Claire so she can start us off on how we can sort of set up a bond and the things you need to think about when you're setting up a bond as part of a building project.
Thank you very much, Mathias. So we're all aware, certainly in the UK, of the sort of current economic climate at the moment, and cost of securities are being reported, not just by our client, but generally in the press, is increasing, particularly in the UK, where we've seen some big players go under recently, and that's had an impact on the bond market. So the cost of securities is increasing. So I suppose just thinking about setting up your project, the first question is obviously, is it really required? Now that will depend on the credit rating of the contractor or the subcontractor, and perhaps on the longevity of the relationship. Is there anything else you can put in that contract to give you the security that you want from the security, or is it required? If you do really insist on it, it is likely to be added to the contract price. Obviously, that depends on what everybody else is doing, but if everybody else is in a similar position, it increase the price of the work for you if you insist on it. So it is worth thinking about alternatives, perhaps, given the current difficulties. Could you have more retention? Could you could change the payment schedule, etc., to give you more security? So there's various different ways of looking at it, but it's certainly something to think about at the moment, because the cost of these securities is increasing, and that will go to the bottom line of how much it costs to do the work. So the second one is obviously, what is it? Now, Mathias has already given you a very good summary of why it can be so hard to work out what you've actually got. But don't come and ask or work out what you've actually got when you need to rely on it, because it may be too late. You need to know when you get it what you've got, and before you accept it, essentially. And all too often that doesn't happen. Often these things are based on precedents. They've been tinkered with over the years, and you see all sorts of weird combinations, and even the courts have difficulty in working out what these things are. So if there is doubt, raise that before you've committed yourself in any way. That can be for both the contractor and the employer. It could go either way in terms of who's going to benefit from the error. So some things to look out for: if it's incorporated the Uniform Rules of Demand Guarantees, which are the ICC rules on this, that's likely to be a sort of more of an on-demand type instrument. Incorporation of a conclusive evidence clause, i.e. you don't have to look at anything underneath or the underlying contract. Again, that would probably be suggesting that it's meant to be an on-demand. If it's not a financial institution, it's a parent company, that would suggest it's more likely to be a guarantee than an on-demand. Very unlikely that parent would actively want to have the right for you to just put in the paper and pay out immediately. Maybe the wording suggests that the bank's liability is not secondary, it's a primary liability. You will pay on demand. Again, that's a clue that it's an on-demand. If there's no exclusion of what otherwise would be defences to a claim, again, on demand. And quite often with parties in different jurisdictions, and I'm thinking wider internationally, then that is maybe hinting that it's likely to be on demand. That's not determinative. We do see a lot of parent companies, for example, based in tax havens, Jersey, Guernsey, etc., especially in the UK, but that could be another tax haven internationally. So it's not, none of these are on their own determinative. You need to look at the wider picture and look at the instrument as a whole. But as I said, you need to do that at the beginning when you've just been handed it. So safeguards for on-demand bonds. As I said, the test for fraud is very, very high, and you only have to look at the facts in the Libyan greenhouse case to realise how high that test is, albeit that's from the 1970s. So do you want to, any additional documents need to be presented with any demand that would give you comfort that that's not going to happen? Who is required to sign the demand? If somebody's putting their name to something and there's any hint of fraud, that's their personal reputation on the line. So, if it's a professional, it's an engineer who's involved with the project, if it's a director, they have a reputation to uphold, that could be a way through. As Mathias has said, hybrid forms could provide some more sort of a layer of protection whilst, it's negotiation. And then there are these rules that can be useful, set of contractual rules published by the ICC. We do see issues arising out of those as well, so people quite often tinker with them. But they do include safeguards. So, for example, Article 15A, the demand is supported by a statement by the beneficiary indicating in what respect the applicant is in breach of its obligations under the underlying relationship. So somebody's actually having to say there has been a breach and what that breach is, and it may be in specific form, but it's all giving you comfort that somebody's really paying attention. They're not just signing a piece of paper and going, I want 100 million. It's really sort of trying to provide some security that you've got some protection. Who is the security from? Bondsmen, check their financial strength. One of my colleagues was saying, I think it was about 20 years ago, the client had been issued with a security from sounded like an insurance company, but they didn't have any money So, you know, don't accept the security without doing your due diligence. Now, for JP Morgan, that's not going to be an issue. We even thought it would be, but if it's a name you haven't heard of, you just need to check, because it's worth doing, and that applies to all securities. It's not just on demand. It's guarantees as well. Are they worth any money? So parent company guarantees. Do they have any assets? There is no point getting a guarantee from an entity that has no assets, because it doesn't give you any security. What jurisdiction are they located in is also worth working out, partly because it can be hard to work out if there are assets in a company that are located in certain jurisdictions because of all the protections and the secrecy around that. Can you trace the assets? How easy is it to transfer assets out of that jurisdiction if they're trying to avoid their responsibilities? And how easy is it to enforce judgments in that jurisdiction? So just all things to think about when you're being offered securities from around the world. So with that, I'm going to hand back to Mathias.
Thanks, Claire. So the other really important aspect about drafting bonds and the underlying building contracts is to make sure that the two actually do speak to each other, and rather than just acting as almost like ship passing through the night, because quite often, particularly under the time pressure of a tender process, you might have different people working in silos and drafting the bonds, and then the underlying building contracts working separately, but not actually talking to each other and putting them together to see whether they actually work together. I say that in particular because with most building contracts, in particular a lot of standard form contracts, you will normally have provisions within the underlying contract which tells you what is required in terms of the terms of the bond and the basis on which it can be called, and also when the bond should or should not expire. So that sort of thing obviously has an impact and overlaps with the actual terms of the bonds itself. Now, if you have a suite of contracts which is standard form, drafted together to be worked together, and you don't amend them, that probably wouldn't throw up too many issues. But in most cases, at least in bigger projects that I've seen, you would normally have bespoke amendments to both the underlying contract and also the bond itself, depending on particular requirements sometimes from the bondsman. So when you do that, you have to make sure that the amendments actually do flow through the documents, rather than just having some amendments made to one document and then another set of documents completely unamended. What might happen if you leave that sort of inconsistency in the contract before you sign it is that when you actually get to calling on the bond, or actually facing a call on the bond, there would most likely be a dispute about, well, which set of terms actually takes priority. They actually tells you slightly different things. So just to give you two particular examples of very sort of common inconsistencies that we see when a dispute arises about a bond call. First type is when you look at the bond and the underlying contract, and they provide for different expiry or termination provisions. So you might have a contract which says, the bond expires upon practical completion. But then you look at the bond says, well, it expires on a particular date, which is some time to the future, possibly even past the defects liability period. So that's the first type of inconsistency. And then the question arises, well, has the bond expired or not when you reach PC? The second type of inconsistency is as to the sort of requirements or the conditions on which one can actually make a demand on the bond. So take one example. If you have an underlying contract which provides that the contractor has to provide some form of on-demand unconditional bond, but somehow the bond provider has additional conditions attached to the requirements for making a demand, then again, there are likely to be disputes between the parties as to, well, should I treat that as an on-demand bond, or is it actually as drafted in a bond, which is some form of a hybrid conditional bond which requires those conditions to be satisfied? And this sort of dispute actually has sort of made its way to the court. So taking one particular example, the case that you see on the screen is the Simon Calf's case, which Claire has also mentioned a bit earlier. And this case is actually quite an interesting one, because it's one of those cases where you have to look at whether a call on the bond would be in breach of the underlying contract. So going beyond the fraud exception, if you, by calling on the bond, may be acting in breach of the conditions for calling on the bond under the underlying contract, the court might still actually restrain you from calling on the bond. And this is a very good example of that happening. And in this particular case, the inconsistency is precisely about the inconsistency or the mismatch between the expiry date of the bond, because the underlying contract says that once you've issued an acceptance certificate, which is the equivalent of a takeover or a completion certificate and under other forms of contract, the bond will be null and void and has to be returned by the surety, or at least actually returned to the surety, so that it cannot be called or relied on any further by the employer. But the bond itself doesn't say that. The bond only says that there is a hard deadline or expiry date sometime in 2020. So the question was, okay, well, there is a certificate, acceptance certificate, which was issued before the expiry date set out in the bond. Can the bond still be called upon because it hasn't technically expired yet under the terms of the bond? And the court actually said, no, you can't, because by allowing you to call on the bond after the acceptance certificate, that would put the employer in breach of the underlying contract, because it only allows for a call to be made before the acceptance certificate was issued. And on that sort of basis, actually the bond should be treated as null and void because of what the underlying contract says. So that sort of dispute can be avoided if you actually think about these things and read all the contract documents together to make sure they're consistent at the tender stage before you actually sign on the dotted line. So quite important, I think, to bear in mind. And that's not the only type of inconsistency you see in contracts and bonds, though, because you then look at the sort of dispute resolution provisions as well, and you might think, well, that should be simple enough. You have the underlying contracts, you've got the DPR, some form of multi-tiered DPR, so what can go wrong? But actually, when you look at them, sometimes you find the underlying contract may have a DRP which says, oh, yeah, you can go to arbitration or you can go to adjudication, but then when you look at the bond itself, that may well actually be silent. And it might just provide for some form of a jurisdictional clause or some form of governing law clause, which suggests that it has to be litigated on in court. And I've certainly had recent experiences of that in recent arbitrations where you have such as a bond or a guarantee from a parent company, which is attached to an underlying building contract. But then when you actually get to an arbitration of trying to arbitrate on a dispute under the underlying contract, there is an open question as to whether you can also refer a dispute under the bond or the guarantee to the same arbitration, so that all of those issues can be dealt with together. And that arises more often than not on a guarantee where it's provided by a parent company or an associated company of the contractor under a contract, because in those circumstances you might want to start an arbitration not just against the parties to the underlying building contract, but also the parent company, because you can then call upon the parent company to pay under the guarantee, even if the employer or the contractor, they are actually the SPV under the contract. So in those circumstances, it becomes particularly important that you have some form of consistency in terms of the dispute resolution procedures. And if you don't think about that, and when you actually get to the arbitration, the other side raises a jurisdictional challenge, obviously that is a bit too late. And all you can do by then is probably to try and argue that, well, if you look at the underlying building contract, the arbitration clause says that the parties can refer a dispute, any dispute arising out of or in connection with the contract, that may or may not be able to save you and allow you to refer a relevant or related dispute under a related guarantee, and then you'll be sort of at the mercy of what the tribunal thinks. And even if the tribunal rules one way, that award itself might be subject to challenge later on the enforcement stage if the parties actually feel like doing so. So that sort of opens up a risk which can otherwise be avoided had you actually thought about this issue at the contract drafting stage. A related question is really about the governing law or the jurisdiction clause that you put into a bond and an underlying contract. And I think particularly for a bond, it's actually quite important to not just think about all the things that we've already talked about, but also think about what governing law you want to choose for your particular bond. Because as Claire said, there are different approaches in terms of the grounds you can rely on to resist a call on the bond. So perhaps for both employers and contractors, that's quite an important consideration. From the employer's perspective, obviously you would want to choose a jurisdictional governing law which gives you maximum protection, so that there are very limited grounds for resisting a call on the bond. From a contractor's perspective, it's more the other way around. You want to have more options to you if you were facing a call on the bond, and you want to potentially resist that call on the bond. So just very briefly comparing some of the different approaches, just to give you a bit of a flavor. I'm not saying that you should choose one or the other of these sort of governing laws over one another. They all have sort of different features, but it's just to give you a flavor of why it matters to think about this issue. So English law, as Claire has very hopefully summarized a bit earlier, you have very limited grounds for resisting a call on the bond, other than in the case of a fraud, or perhaps if you are going to be in breach of the underlying contract by calling on the bond. So those sorts of grounds, those are really the limited grounds on which, under most cases you can see in the English courts, those are the grounds that you can rely on to resist a bond call if it is governed by English law. And the same applies to Hong Kong law as well, and others, most other common law jurisdictions which follows this sort of approach. But then if you look at other common law jurisdictions such as Australia, you might start seeing grounds which starts going a bit further from the English position. So in Australia, for example, there have been cases such as the Reed Construction Services case that you can see on the screen, where the court might actually grant an injunction preventing you from calling on the bond if there has been a promise between the parties of, let's say, a promise from the employer after a breach of contract or otherwise, telling you that they would not call on the bond, and that sort of promise might actually be enforceable. Now, that case law has actually slightly sort of developed in Australia since then, and has been confirmed. In the UK, we haven't had that sort of situation until quite recently, back in 2020, where there was one case where the court was willing to prevent a bond being called on by relying on an undertaking given by the employer that they wouldn't call on the bond unless there was a breach of contract, and the court was satisfied that there wasn't any sort of viable, credible allegation of a breach of contract. It's a case called the ETC Export Trading Company. So perhaps the difference between Australian and English law isn't really that stark anymore, but nonetheless, thinking about that sort of issue is really quite relevant at the stage of contract drafting. And then you look at other sort of going a bit further from Australia and England, you go to Southeast Asia, look at Singapore. Singapore is a particularly good example because Singapore actually adopts quite a different approach. So going beyond fraud and breach of the underlying contract, you have situations where an employer can actually not call on the bond if the court considers that call on the bond to be unconscionable. So you're going into arguments such as good faith, bad faith, and things like that, whether something is fair or not. And that is really something much, much broader than the other grounds that you can normally see in English cases and even in Australian cases. So if you choose a bond which is governed by Singapore law, for example, then you will have to be prepared, as an employer, for example, you have to be prepared to face arguments about conscionability if you were to try to call on even an on-demand bond. And then finally, moving back to the Middle East, UAE law, of course, is not a common law jurisdiction, but even under the Civil Code, under Article 417 of the Federal Commercial Law, there is a discretion for the court to basically give an attachment order and ring fence the sum which is drawn down under exceptional circumstances. And they are looking for what they call serious and certain reasons for doing so. So that's not exactly unconscionability like in Singapore, but nonetheless, it gives the court quite a wide discretion to think about whether it's fair or just for a party to call on the bond and whether some security should be given to the contractor if their bond is being called. So, for example, if you put forward evidence that the call might actually be disputed on genuine grounds, or if the contractor is actually owed substantial sums from the employer, and you have substantial cross claims, that might actually give the UAE courts a discretion to restrain or at least provide an attachment order to secure the sum which is drawn down on the bond so that it doesn't get dissipated. So those sorts of considerations about different jurisdictions, they're not exhaustive, but it's certainly something that you must think about when you are drafting the bond and deciding which area of law you want to use to govern that particular bond. And if you don't do that, obviously, then you might open up yourself to disputes sort of further down the line. If you do that, then you would see that even if your bond gets called, let's say if you have a bond which is governed by English law, but it's being called somewhere in another jurisdiction such as Singapore, they might at least still give effect to that governing law and apply English law principles and English law standards and not Singapore law, which, as I said just now, contemplates arguments about unconscionability. So something to think about if you are at that stage of drafting a bond. So on that note, I would just hand back to Claire to talk about counter securities.
Brilliant, thank you, Mathias. Well, going back to this theme of governing law and jurisdiction, with a sort of typical setup for an on-demand bond internationally, you may have various different players in different jurisdictions, and this is where the importance of the jurisdiction and the governing law is really cannot be emphasised enough. So if you look at this diagram I've got, say the employer, I'm going to take the NIDCO case as an example. So The employer is in Trinidad, and the contractor is based in Brazil. The contract is subject to, I don't know, English law. Number two, the contractor has to get their bank, which is in Brazil, to basically give them sort of a contract that they will help issue a bond because the employer wants it in Trinidad. Contractor's bank then reaches out to an issuing bank, which may be an entirely separate bank. It could be a bank that's related to them, or it could be a different bank. Say an English bank, the issuing bank. So you get the security from an English bank, and that is issued to the employer who's based in Trinidad. But there is also a sort of equivalent on-demand bond between the issuing bank, who we said is English in this example, and the contractor's bank in Brazil. So there's another contract in that. Why does this matter? Well, this is quite an interesting case, which went to the Court of Appeal. So NIDCO versus Banco Santander. Brazilian main contractor is in administration, and straight away there's an issue there because the bank may not get their money back. If they hadn't been in administration, different potentially. Standby letters of credit issued subject to English law and jurisdiction of the English courts to the employer. The counter indemnity that I've just shown you on that diagram is from the Brazilian banks to the English banks. Then you get an injunction obtained in the Brazilian courts against the Brazilian banks. So the Brazilian banks are being prevented from paying out to the English banks. So English banks are like, ooh, I might not get my money either. And just to make matters worse, the Brazilian courts later extend that to cover the English banks, although whether the English banks would pay attention to that is another issue. So English banks are left concerned they're not going to be paid out, and the Brazilian banks are very concerned and conscious that they don't have enough money to get paid if this demand is made. So in the NIDCO case, you can see that you end up in court essentially having to enforce payment against the English banks. The courts did order payment eventually, but obviously there are additional costs in terms of enforcement and delay. And English courts have a very robust, generally speaking, approach to enforcements of these sorts of securities, in contrast to the Brazilian banks. So you can see why the location of the bank you're getting the security from, as well as the governing law and the jurisdiction clauses, is all very important in terms of making sure you're protected if you want to make a call at the end, that there isn't going to be something you haven't thought about sort of getting in the way, essentially. You don't want to end up in the Court of Appeal. So when do things go downhill? What should you be doing? There are some basic things, and I'll go through them before I hand back to Mathias. Always check the expiry date on your on-demand bond. Sometimes that's obvious, it's a date. Sometimes it isn't, but you need to know what it is and think about it and have it diarised months beforehand, so you have a warning flashing up. Obviously, what grounds allow a call under the construction contract in question? For the employer who's thinking about making a call, you need to make sure that you've got all your ducks lined up in a row. That may involve issuing various notices under the construction contract. Do it in advance. There's obviously time. There are often time scales. If you've got a hard cut-off date, you need to work when those cut back, because you've got a deadline. Obey the formalities for on-demand bonds to the letter, especially if the URDG applies, but generally, and that can include really things you wouldn't think about, like company seals, signatures. The wording has to be exactly as required. And just to give you an example, this case, it required a statement that the delivery of a vessel had been delayed by more than 270 days. And it was a requirement to slavishly follow the wording of the refund guarantee. And a failure to follow that was fatal. The refund guarantee required not a statement that there had been 270 days delay of any character, which entitled the buyer to cancel, but a statement that there had been 270 days delay of a particular character, which entitled the buyer to cancel, namely that set out in this article. So you really need to look at what you need to do, especially if it's about to expire, because you may only get one shot at it. As I've said, think about who has to sign this. If they're in a different place, hard copy, except you have to plan in advance. Company seals, the NIDCO case took a while to work out which one was applicable. So just work that out in advance. location of the institution you have to serve on. Do you need to consider a process server? How are you going to serve it in that location? How are you going to make sure they acknowledge you've served it, or if they refuse service, what are you going to do? Do you have to chuck it across the fence and do witness statements, etc.? You need to think about these things in advance because they do happen. Contractor's perspective, face reality. Don't bury your, don't adopt the ostrich approach. Resisting a call on an on-demand bond on a release is very difficult. Look at if the call will be a breach of the underlying contract. Again, if the employer hasn't got their ducks in a row and they haven't issued the right notices, that might be an angle. Deal with the underlying claim proactively and if possible. If you know you've got a bond there that they can call on, you might want to alter the tone of your language or the way you approach it, how quickly you get into the detail, or you put more detail on your claims, flesh on the bones, etc. If your on-demand bond is about to expire and there's a dispute and there's amounts that might be claimed, consider extending it. You need to balance up the costs to your business of a call being made, and that may mean you've got difficulties getting bonds in the future, versus paying up the cash, or paying up some cash to try and stave off the call. Don't play the sort of who blinks first, because that can be really dangerous in the context of an on-demand bond. It can do, a call can damage your ability to get bonds for other projects, which can affect your business in the longer term. So it's opening your eyes to all the implications of a bond call and thinking about it and how you can stave that off if possible. So I'll hand back to Mathias.
Thanks, Claire. So I'm going to talk very briefly about when things go downhill, but in the context of guarantees and conditional bonds. So quite similar considerations, actually. From an employer's perspective, if you are trying to make a demand under guarantee or a conditional bond, such as the ABI form of bond, then you need to even go a bit further than what Claire has just said about the sort of usual formalities for an on-demand bond, and think about what do you need to do in addition to meet the more onerous conditions under a bond, which is conditional. So taking the ABI form of bond, for example, you'll remember that we've looked at the wording, which is that you need to establish and ascertain the loss and damage in accordance with the terms of, by reference to the contract, and also taking into account any sums which may be due to the contractor. What that means is you have to go through some contractual mechanism to establish that sum of money that you say that you're entitled to in order to rely on it to call on the bond. And that means a bit more than just issuing an invoice or writing a letter to the contractor saying, well, I think you are liable to pay me X sum of money. That itself is not important, is not sufficient, because what the bond actually requires is for you to establish and ascertain the loss properly. And that requires some form of an independent process, which takes it outside of the hands of just the employer itself. So there's been quite a bit of case law, in fact, giving us a bit of guidance on what you need to do when you're faced with that sort of a bond. So Cigarette and HTC International, that was a case where the contract was actually terminated because of an insolvency. And the question that the court had to decide was, well, in that sort of situation, how can the employer actually call on the bond where the contractor is insolvent and has been terminated? And the court basically confirmed, amongst other things, it's quite a lengthy decision on various other issues, but the court confirmed that in those sorts of situations, they were dealing with a form of contract called the JCT contract, which, of course, for those who are based in the UK, shouldn't be a stranger to the JCT at all. But essentially, what the JCT contracts have is a provision under the termination provisions, which allows the parties to put together a termination account. So the employer would basically take all of the sort of sums which are due to the contractor and also the sums which they think are due to the employer, and sort of carry out some sort of netting off exercise to calculate what is the net balance due post termination. And that sort of process is normally carried out not by the employer itself, but by, let's say, a contract administrator or an architect under the contract, or a project manager, someone who is basically meant to be relatively independent under the contract and administering the contract in that sort of role. And that in that case, the court confirmed that you can actually just have that sort of post-termination accounting process as the ascertainment process required by the bond. And once you've ascertained this loss using that contractual post-termination mechanism, that is sufficient for you to call on the bond, but not before. So you can't just terminate the contract and then send an invoice to the contractor. You would need to go through the contractual procedure for formulating the final accounts. So that's cigarettes. Yuanda and multiplex is the second case, which gives you another example of what you need to do. And in that case, there wasn't necessarily a termination, but there was basically an employer who had an adjudication decision awarding liquidated damages to them, and they wanted to call on the bond in order to discharge those liquidated damages. And the court confirmed that the adjudication decision itself was sufficient as an ascertainment of the liquidated damages due under the contract. But on the other hand, if there wasn't a decision from an adjudicator, which is independent, but only some form of a payment notice issued by the employer itself without any independent certification process, then that sort of payment notice would not have sufficed for a demand on the bond. So long and the short of it is, if you have a bond which is similar to an ABI bond, you would need to think about going through either some form of contractual sort of accounting mechanism, or you have to go through an independent dispute resolution process, such as an adjudication, in order to ascertain the loss. That, of course, means more time and cost before you can actually call on the bond. Similarly, for a guarantee, you again need to establish some form of underlying liability first. And that actually means a bit more than just going to an adjudication normally, but actually going all the way to an arbitration or litigation most of the time and getting a final determination that there is some form of underlying liability under the primary contract. And then you can then call upon the guarantor to perform their secondary duty of paying you based on the underlying primary default by the contractor or the employer, whichever the case might be. What all of this means is that just don't assume that it's necessarily a quick fix to try and call on a conditional bond or a guarantee, because that process of getting some form of ascertainment or some form of decision of the primary underlying obligations or underlying breach can take a while. So one case which I did quite recently, back in 2021, 2022, was the Energy Works Hull litigation in the TCC, which actually I did with Fenwick Elliott back in the days. And that case itself was quite long. I mean, from the points when we issued proceedings thinking that we want to call on the bond because we were worried that it would expire, that was in 2019. We only got judgment in December 2022, and that was 3.5 years now. Of course, COVID might have had something to do with it, but actually we were already proceeding on an expedited basis in that particular trial. So that gives you a sense of how long it can take if you only had a guarantee. And in Energy Works, we did have a parent company guarantee, but we couldn't actually rely on that guarantee and make a demand under that or get payments under that unless and until we had that decision 3 years down the line after we started proceedings. So again, if you want to have something which is quick, the on-demand bond route would probably be the quickest one, whereas conditional bond or guarantee wouldn't necessarily give you that benefit. So from a contractor's perspective, actually, it's really quite similar to what Claire has already covered for on-demand bonds. One particular thing I think you need to think about is the sort of cross-indemnity or indemnity agreement you have with your guarantor or bondsman, because there are cases where sometimes if the bondsman or the guarantor is faced with a potential demand on the bond or the guarantee, that might actually start or give rise to an entitlement on the bondsman or the guarantor's part to draw on any cash that they already have. So if you have a bank who is a bondsman or a guarantor, for example, they might actually take that cash or freeze that particular asset, and you can't use it anymore as long as they've been faced with that bond call, even if that might later on be proven to be invalid, or if there is an ongoing dispute or an attempt to try and restrain that call. So be very careful about the terms of the indemnity agreements. Know exactly when you have to reimburse the bondsman and guarantor, what sort of money you have to put up and when, and make sure that you have the resources to do so, because obviously, getting the bond called is already bad enough, but defaulting on an indemnity agreement on the back of that, again, is probably going to just to make things worse, both in terms of getting future bonds and also your ability to procure future projects. So something to really bear in mind, not just at the dispute stage, but actually when you're drafting bonds and procuring a bond for the purposes of getting a contract. The other thing to think about, of course, is again whether there's some sort of commercial resolution possible to avoid a call on the bond. So extending the expiry of the bond, as Claire was talking about just now, or the expiry of a guarantee as it may be. That is obviously one potential option. But the other option, of course, if you already have ongoing proceedings and there's a threat to call on the bond in the meantime, you might think about some form of payment into court so that the other side would have some form of security and you can avoid a call on the bond even though you are putting cash forward. You might also think about making an on-account payment to the employer instead, and maybe trying to arrange for a ring-fence account for it to be put in if you have any concerns about the solvency of an employer. And doing that has the benefit of avoiding a call on the bond and avoiding your sort of reputation in terms of your ability to get future bonds and get future projects. So it's really a sort of cost-benefit balancing exercise in every case, like with an on-demand bond. So finally, on that note, I would just want to tell you very briefly what sort of remedies, if you are a contractor, what sort of remedies you will have if you get a bond call and you think that that is wrongful. So let's assume that in sort of the ideal world, your bond has been called on, but you can actually establish that there's been a wrongful call on the bond because the employer couldn't actually establish a breach of contract on your part. What then can you do? The primary remedy when it comes to bond, at least under English law, is that you can get any sort of sums which are overpaid under the bond, and you can sort of recover that from the employer. So that is the sort of accounting exercise, basically, that you have to carry out if you were to, let's say, try and establish that there was no breach, and in that case, but the money under the bond was paid out wrongly. And Cargo International, that is the sort of decision which sort of confirms that principle that you can have that accounting exercise at the end of a dispute, because that is really the fair thing to do, so that a party wouldn't get overpaid under the bond. But going beyond the accounting exercise, which is the normal remedy, one sort of starts thinking, well, can I get a bit further than that? Can I get any other damages out of that potential sort of wrongful call on the bond? Is it a breach of contract? The problem with trying to get damages for, let's say, increased financing costs or a loss of opportunity or a loss of revenue is that it's likely to be quite difficult to prove, not just on the quantum, but also in terms of just establishing a breach of contract in the first place in terms of the call on the bond. Because it's not necessarily clear that, just because an employer called on the bond, but is somehow later not able to prove that alleged breach, that is necessarily a breach of contract. So you've got case law in England, such as Constate International. That case confirmed that there is no duty of good faith or no duty to call on the bond only where there is an actual loss being proven. You get cases such as NW High Tech and Biffa, which is another well-known case, where the court confirmed that there's no implied term requiring a demand of the bond to have a contractual basis even. So a bond can be called validly even if there is a genuine dispute over the claims, because otherwise almost every call on the bond could somehow be turned into a breach of contract. So crossing that first hurdle would be very difficult. So one shouldn't operate under any illusion that's going to be an easy claim. But even if you get past that, when it comes to the quantum, it's going to be very difficult for you to probably prove that there has been some form of loss in revenue directly attributable to the call on the bond. And I've had sort of arbitrations before where one party has tried to establish some form of financial damages arising from a wrongful call on the bond, or what is said to be a wrongful call on the bond. But the evidence that they've put forward actually shows that they've actually had more opportunities or business opportunities by procuring new contracts after the bond was called on. So they can't even actually show that they've started losing business. Quite the other way, they've started gaining a bit of business quite counterintuitively after the bond was called. So that sort of thing would prove to be quite difficult. And so perhaps the best thing to do when you have a bond which is wrongfully called is to focus on the accounting of the sums due between the parties as the primary remedy, and only when you really are sure that there is some loss of business that you can clearly show is attributable to the wrongful call on bond should you actually go down that route. So on that note, I hope that's been helpful. I think in summary, basically, just think about the form of the bond and the terms of the bond early on during the drafting stage. Make sure that the underlying contract and the bond are consistent. And then when things go downhill, be very careful about the formalities you need to fulfill in order to call on the bond, both in terms of the format of the demand and also the conditions you need to satisfy. And then when you actually can get to the stage of trying to get back the money under the bond because you think it's wrongfully paid out, only focus probably on the sums wrongfully paid and not so much on damages for breach of contracts, unless you can clearly show that there is some form of breach attributable to that wrongful call on the bond. I'm not sure I've missed out anything, Claire. If there's anything you want to add on that?
I don't think either of you have missed out anything. That's been super thorough, and there's been a lot of information and a lot of very relevant and very practical information for everyone. So I thank you both very much for that. There's just time, I think, for a couple of questions. And there's been one they're sort of related, because they've both been talking about the current economic market. So one question has said that in the current economic market, they are seeing an increasing number of contractors unable to obtain pure on-demands, and sometimes adjudication bonds are being offered instead, and they are wondering whether that was your experience. And then another, someone has come in and said, aside from increases in costs, have you seen any other changes to the accessibility of companies being able to get performance bonds? So I mean, there's people looking at, so what other changes apart from costs you might be seeing in the market? I don't know who wants to jump in.
I think the first point is it's not just about costs. Some people may just not be able to get those securities. They just might not be available. And yes, a switch to more security, that the claims made are going to be backed up somehow. So yes, no, just generally a hardening of the market in terms of how easily this stuff is available, and where it is available, the costs are going up.
Yeah, I would agree. And I mean, just in the past year, actually, I think I've advised on at least 10, 20 of these sort of different types of bonds being called on and whether they can be called on. So there's certainly, I think the market is rightly sort of quite wary of bonds being called these days, and trying to make sure, if you are the bondsman, for example, you wouldn't want to give an on-demand bond too readily, because there is a real risk that actually you have to pay out under that in the current sort of climate. I mean, certainly in terms of sort of on-demand bond versus adjudication bonds or other forms of bonds, from the bondsman's perspective and also from the contractor's perspective, that might be helpful, because that would make it harder to call on the bond, and it would take longer, as we've sort of shown just now throughout the past hour. From the employer's perspective, obviously that would be more difficult, particularly if you have an insolvency situation. So I've had cases where there is a bond which is a bit like an ABI bond, and they need to ascertain the loss, but then the contractor is insolvent. So can you actually go through an adjudication when they're insolvent just to establish some liquidated damages? It's going to be difficult without the consent of either the liquidator or the administrator or the court. So that sort of complication does arise, and something that needs to be thought about, I think, when you decide which bond to go for.
Okay, no, that's all very helpful. And just as a final point, we can talk about some of the things that you need to do, some of the practical or technical steps you need to take to comply with the requirements of a security, and quite often the concept of needing to establish and ascertain something is referred to in the wording. How do you establish and ascertain? Do you just have to follow the requirements of the particular contract, or do you have to go a further step and perhaps get a court judgment or adjudicator's decision?
Yeah, well, it would depend very much on, I mean, it's a very lawyerly answer, but it would depend very much on the terms of the bond and the terms of the contract. But generally speaking, if you have something which is based on the ABI form of bond, you don't need to go all the way to the courts, which is the good news. The bad news is you do need to do something normally. So in some contexts, if you have a sort of contract administrator who can independently operate the contract and certify a sort of final account or termination account or some form of payments, then that itself might comply with the procedure for establishing and ascertaining it, because it's an independent process. It's not just an employer issuing an invoice itself saying that the sum is due. If you don't have that sort of independent certification process under the contract, then the likelihood is you would need something like an adjudication, which is the quickest to get, in order to establish the loss. If somehow the contract is not subject to adjudication, then you're probably right. Then you might have to actually go to court to actually get that, and that would take much longer, obviously.
Or think about putting some amendments in, so it's clear what you need to do and when.
Absolutely.
I mean, yeah. Think practically. Try and think ahead. Is always good advice when you're putting these documents together. But just want to say, Claire, Mathias, thank you very much again. It's been much appreciated for the time and effort that's gone into producing such a very detailed webinar for us. So thank you both very much. And as I said at the outset, this is our final webinar for 2023, but we'll be back in January of next year, and we'll provide, look on our website, provide details of upcoming webinars. You can check our YouTube channel if you want to catch up on demand with some of our previous webinars. So wish you all the best for the end of 2023 and all the best for 2024, and hopefully we'll see you all in January. But thank you all very much indeed.
Thank you very much.
Thanks, everyone.